Hearing none and hearing none and seeing none, if there are no corrections, the minutes are approved as distributed. The next order of business on the agenda is the committee report. The Emerging Issues and Orders of Protection Committee met this morning in a separate Zoom meeting. We will now hear from our Emerging Issues and Orders of Protection Chair, Ms. Michelle Contiglio-Young. Michelle?
Good morning. Yes, so our committee met this morning. We met starting at 9:05, and we had a couple things on the agenda. First, we discussed, continued a discussion on the third party contact information on the affidavit of firearm dispossession form. And just as I know that this group knows, and as I had rehashed with our committee, we just went over a little bit of history of it. We've been discussing that for a couple of years, well, more than a couple of years, for on and off for a few years. This larger group referred the issue to us back in March for official discussion and recommendation. We, as a committee, took up the discussion at the June meeting as well as the September meeting. And we just could not come to a consensus on recommendation and exact language to recommend. I had discussed it with Chair Melanie Bean before this meeting, just to say that, I'm not sure that our committee is going to come up with specific language, which ended up being fine because clearly they're on the agenda for today is a discussion of that with proposed language on forms that various counties use. So our committee's decision was to just make no recommendation to this larger group, allow the larger group to discuss it as on the agenda today and come up with any recommendations or form language that the coalition or the council would want to implement, promulgate, and draft up. So that's where we are on that. So there is no recommendation from our group. Well, we are allowing this larger committee group to discuss it. And also we felt that was appropriate because in the code per TCA 36.3.325E, it does say that the any changes would be promulgated and done by the Domestic Violence State Coordinating Council in consultation with the AOC. So we're going to leave it there. We know that there'll be discussion in just a few minutes on that. And that's where our committee landed. I will say, just for the record, for the court system and for the AOC, I will have to abstain on any vote on that just because we promulgate so many forms per statute that it would be a slight conflict for us. So I just wanted to put that on the record. But also what we discussed in our meeting, we did just purely for awareness, the couple of legislative matters that went into effect that passed during session. One is Public Chapter 511, which goes into effect January 1st of this year, of 2026. So coming up on January 1. It's a mandatory mental health evaluation for certain offenses. And what's pertinent to this group is that there would be a requirement for outpatient evaluation before sentencing for domestic assault offenses, as well as child abuse, aggravated child abuse, animal cruelty, and aggravated cruelty to animals. The Department of Mental Health is tasked with coming up with that evaluation, with the process, with promulgating any rules that would be connected to it, as well as distributing any forms. We at the AOC have been working with Department of Mental Health on the forms and different processes for that. And when the Department of Mental Health finalizes the process in forms, and we will either link that on our website to them or put something on the AOC website. But I just want everyone to be aware, because I think this is something just to be sure that everyone knows that's going into effect January 1. And I do think some of it we'll just have to see how it happens in practice and what the impacts are and whatnot. But that's something that I know the court system and Department of Mental Health will be monitoring, and I know the coalition is as well because they were aware of this bill. And then the last thing we discussed, also just for awareness, was Public Chapter 481, which went into effect July 1st of this year, and it requires mandatory behavioral training for Class A misdemeanors. that are in general sessions court. So it specifically says that it's for Class A misdemeanors in general sessions court, and that the behavioral training must be accessible, affordable, but will have to be paid for by the offender. Most counties have this ability and these trainings available, but for counties that don't, I think that's where any discussion or within the county would need to come up. So I just want everyone to be aware of those two, and we may have to talk about them a little bit more once we can kind of see some numbers and see how the actual impacts are once they're in effect. This one particularly in a little bit longer. So those are our discussions during our committee meeting this morning, and that's all I have to report.
All right. Thank you, Michelle, for your report and for the committee's work that they've done thus far and continue to do. Does anyone have any questions for that committee? Is there a motion made on any committee issue? I don't know that y'all have made any recommendations for there need to be.
We did not.
Okay.
Yeah. Thank you.
All right. Okay, now for the certification and monitoring review. They met this morning in a separate Zoom as well. So we will now hear from Brandon Woosley or another designated member, if not him, about the committee.
In the BIPS committee meeting this morning, we discussed 6 different organizations. 5 of them were recertifications. 1 was a new applicant. Of the 6, there were 2 organizations, BrightPath and Time for Change, that we are recommending for full approval. They had no outstanding documents, no deficiencies, and they made their payments. There were 2 organizations, Family Counseling and Choices. They submitted everything. They made their payments. We just noticed minor problems with 1 document each. So we were recommending a conditional letter of approval. And then once we get the corrected documents, they would just have their approval status. And then there were 2 other organizations, MJM and the TCCS. We are recommending that they reapply and submit the proper documents in the proper locations, in the proper manner. And once they did that, we would reevaluate their applications at that time.
All right. Is anyone going to make a motion to approve the recommendations of the committee?
I make a motion.
Is there a second?
This is Dorisha Davis. I second.
All right. We'll need to do a roll call vote. Mr. Woosley, if you'll please do the roll call vote. For the recommendation to approve BrightPath and Time of Change are the 2 that I think that we're approving. Is that correct?
Yes.
Okay.
We will start with Michelle Consiglio.
Aye.
Chelsea Curtis.
Aye.
Judge Dalton.
Yes.
Dorisha Davis.
Aye.
Deborah Lambert.
Yes.
And Mary Littleton.
Aye.
Kirby May.
Aye.
Judge McMillan.
Aye.
And then Michelle Mowry.
Aye.
Judge Scott.
Aye.
Ilana Tate.
Aye.
Felix Vess.
Aye.
Van Wolf.
Approve.
And I'm an aye.
Secretary, does the motion carry?
It does.
Okay. Next, we'll hear from the training and education co-chairs, Alana Tate and Ashley Parker.
Yes, Ashley could not make it today. Are you able to pull up the training committee sheet because I did not receive that.
Brandon, could you do that? Could you provide that to the meeting?
What am I pulling up?
The training sheet, she said.
Let me see. I'm not seeing it.
It's
Ms.
possible.
Tate, I'm sorry, go ahead.
It's possible that it was with Ashley, who was unable to attend today. She didn't attach that to her email.
Okay. Ms. Tate, can you go ahead and present without that form?
No, ma'am, I cannot.
Okay. Then we will move on, I guess, to the executive committee report. Melanie Bean is obviously not here, but she said there is no report from the executive committee for full council. So we'll move on to the next order of business, which is going to be public comments and new business. The next item on the agenda is to review of the public comments and the new business. As a reminder, all public comments must be submitted to the Tennessee Coalition to End Domestic and Sexual Violence at least 2 weeks prior to our general body meeting. So far, there have been 27 public comments submitted by email to Chair Melanie Bean. Duplicative comments were also received by members of the Emerging Issues and Order Protection Committee. In the interest of preserving time, since all the comments received are essentially form comments with the same content from different individuals, only one comment will be read into the record. So I'm going to read the comment of Ms. Hannah Roberts. It states, Dear Executive Director Melanie Bean, as a concerned Tennessean, I urge you to vote to approve updating the domestic violence firearms dispossession forms for both orders of protection and domestic violence misdemeanor convictions to include the name of the third party to whom firearms are dispossessed, along with identifying information so courts can verify that dispossession has been completed through lawful means. Current Tennessee law requires respondents to dispossess their firearms within 48 hours by any lawful means, such as transferring possession to a third party who is not prohibited from possessing those firearms. This is from TCA 36-3-625 and 39-13-111. Without space on the form to identify who the third party is, courts cannot confirm that the transfer was completed in compliance with the law. Importantly, this change is not only possible, but already working in Tennessee. Scott County's courts have adopted this practice and have been highlighted nationally as a model for firearms compliance and prioritization of high-risk cases. I know you care about protecting survivors of domestic violence from further harm. We know the statistics on the lethal implications of DV offenders having access to firearms. By voting to approve the updated form, you can literally save lives. This update would be a practical, lawful, and life-saving improvement to Tennessee's domestic violence response, and I urge you not to allow any further delays and to vote to approve the updated forms at the December meeting. Now that I've read the public comment, I want to open the council discussion up for discussion on the firearms dispossession form as new business. All the public comments received related to firearm dispossession form and receiving multiple requests from members of the public for this body to recommend a modified dispossession form. Circulated with your materials prior to this meeting were samples collected by our chair, Melanie Bean, from multiple counties demonstrating changes that have certain counties have on their own implemented. As most of you have been members of the council for several years now, there has been tremendous discussion among the council over at least the last 2 years concerning the council making recommendations to the firearm dispossession form. The Emerging Issues and Order Protection Committee has reviewed this issue and has not made a recommendation to the full council concerning proposed modifications to the board without specific committee recommendation. The legislator and the AOC have not adopted model forms. This council continues to be pressed to weigh in on the dispossession form. I suppose any recommendations made by this council, should a proper motion be made and adopted by a vote of the council, that the recommendation would be discretionary guidance at best to the jurisdictions. Multiple forms modified by local courts on their own. We have circulated in advance of this meeting forms from Wilson, Putnam, Scott, Knox, and Davidson County. Putnam, Scott, Knox, and Davidson modifications are similar, which require the recipient of the firearms be identified by name and their contact information provided. And all those forms were attached to the email that I think Brandon, you sent that out a while ago. Wilson County uses a modified form that seems to go a step further, which requires the receiver of the firearms, which would be the third party, to sign. They are in fact receiving the firearms as part of the dispossession. This dispossession form used in Wilson County requires the person to acknowledge receipt and acknowledge their awareness that the person being dispossessed shall not possess firearms and they're accepting the transfer. Wilson County forms reads as follows, and it's highlighted for those of you reviewing the electronic version as I read this. To the person to whom the firearms are being transferred, by accepting transfer of the respondent's firearms, you acknowledge and agree as follows. You are over the age of 18 years and legally allowed to have firearms in your possession. You acknowledge that an order of protection has been entered against the respondent and that he or she shall not possess firearms while the order is in effect, and you agree to accept transfer of said firearms. You agree not to allow a respondent to take possession of his or her firearms prior to the expiration of this order of protection. Affiant, sign here in front of a notary clerk fills out below, sworn and subscribed before me this day of date. Judge Hagan is present and he was invited by Ms. Bean to speak to the council. I would ask him to briefly discuss this form and whether this has worked in his jurisdiction. Judge Inslee Hagan, thank you for coming and being willing to present this to us today.
Sure.
From your perspective and whether or not it's been effective and exactly the impact it's had on domestic violence in your courtroom.
I do think it's been effective. I'll tell you what precipitated this was the tragedy that happened at the Waffle House in Antioch a few years ago in Nashville. And we learned as that case proceeded that the father of the suspect, or I guess the criminal there in Michigan, knew that his son was not allowed to possess firearms, but he turned them back over to him. And we got to thinking here, what can we do to offer another layer of protection when we're dispossessing someone with firearms? And so I've had it, I believe, work very well. Now I will say we're relying on somebody to swear that they're not going to give these guns back to this person. And so, you know, there's a bit of a trust, I suppose, but I think having the recipient, the person who's going to possess them or hold them for the respondent in the order of protection, I think it makes a much stronger impression upon them of the importance of keeping the firearms and keeping them away of the person who has the respondent in the order of protection. That's just my policy, and I think it's worked fairly well. I also require if the petitioner in order of protection wishes to dismiss it, I do not allow them to dismiss that over the phone or via email or something like that. They have to come in and physically sign the order dismissing the order of protection. I think this also makes an impression upon the petitioner of the severity of this issue and how important it is. Unfortunately, you all probably heard about a domestic violence homicide that occurred in Wilson County a few weeks ago. And the victim there did have an order of protection, but they had a divorce case that was pending. And as part of that global resolution, she asked to have the order of protection dismissed. She had an attorney, and the attorney had signed off on it, but I wouldn't sign the order dismissing it without the actual petitioner herself signing the order of protection. Unfortunately, we know what happened there, but that's just my policy. If it's important enough for someone to go and sit with a judicial commissioner for an hour and fill out the petition, I think it's important enough. If they want to dismiss it, they're going to have to actually physically do it. But I don't have any stats to give you about the dispossession of firearms and how effective. That's what I do, and I believe it makes a stronger impression on the person who is taking possession of them, having to do that, being sworn, and having to acknowledge these things when they sign that form, the dispossession form. And Judge Scott, if anybody has any questions, I'm certainly happy to answer them as best I can.
Does anyone have any questions for Judge Hagan or comments they'd like to make? All right, Ms. Curtis.
Yes, I have questions, just kind of logistically. I represent the District Public Defenders Conference, and so I'm not sure, Judge Hagan, if you can answer these or if Michelle Consiglio-Young can answer these, but the questions I have are, do we know of any other states that do this? And then if there are other states that have this third-party dispossession, are we aware of any kind of civil or criminal liability that that third party is assuming? And then where I'm going with those questions is a problem that I kind of foresee, particularly with public defender clients who are often indigent and, well, are all the time indigent and often don't have, family or people willing to vouch for them. And so I'm wondering, because this is a circumstance I can foresee for lots of public defender clients, what are the options for a person who doesn't have a third party who's willing to take on that kind of civil or criminal liability on their behalf? What are those people? What options are there for that person if they do want to dispossess their firearm, but they simply don't have a person in their life who's willing to take on any kind of liability? That's kind of my line of questions there. Thank you.
Yeah, as far as if they don't have someone who's willing to take possession of them, then my circuit court clerk has a safe here in the courthouse, and we will have the individual bring them here. We will store them for the duration of the order of protection, and then they can petition to get it back. As far as liability for the third party who takes possession, by signing an affidavit, in my theory would be if they violated that and it could be proved, then you could charge them with aggravated perjury, which would be a Class D felony. I'm not sure. Luckily haven't had to do this, and I probably should discuss it with my district attorney general, but I'm not sure if it would really qualify. And Judge Scott, you help me. I'm not sure if it would be contempt if they were to do it, because they're technically not a party. They're a third party, and so they're not properly before the court, as we like to say. But I do think if we were to find they signed this, they acknowledged they could not allow the person to have it, and they did it. I think that could be, because they're signing this before the court, I think that could be charged as aggravated perjury.
Thank you, Judge.
I don't know if that answers everything, Ms. Curtis, but that's where I am.
Yes, it does. And that having the option to dispossess them to the
and we've encountered that. Unfortunately, some people don't have family around here, or their family's not allowed to possess firearms, and we've encountered that not frequently, but my circuit court clerk is willing to store them for that duration.
Is there anyone else that would like to discuss the issue further, or?
Let me say, but while I'm with you all, I think this should be legislatively mandated. I really don't. I don't see a good argument against it, and I think putting some teeth in some consequences for the third party, I think would be even better. But I'm not a legislator. That I'll leave that to Nashville. That's where this court, and that's where my mind is.
Ms. Buller, do you have something that you would like to add?
Yeah, I just wanted to address Ms. Curtis's question about other states that do this. From a previous kind of study that we did of the different practices of states, there were 13 that allowed for third-party dispossession, and Tennessee was the only state that had no kind of check or balance or place where that third party could be mentioned in court form. So it is a practice in other states that allow for dispossession. Some do not allow third-party dispossession. They only allow the dispossession or relinquishment of a gun to go to law enforcement or a licensed firearms dealer. But in the 13 states that do, Tennessee is the only one that requires no information on the third party.
Is there anything else?
I just have a quick question, new on the council committee. What has been the reasoning why that language has been discussed? I don't want to go into a long history of it, but is there a reasoning that language about the third party person not be on there? I just, as a former state prosecutor and former domestic violence prosecutor, I see that this, I agree with Judge Hagan. I don't see why that language should not be on the form, personally.
Is there anyone that would like to weigh in on that?
I mean, I can address that. So it like Judge Hagan said, I mean, this is something that has brought up to the legislature. The legislature has had legislation before it in the past, and over, it every few years, they'll kind of they'll see a bill or whatnot that's filed to require that information. The legislature has not adopted or passed that officially. We at the AOC who have been doing these forms, we are limited to putting information on the form that is required by statute. So because it's not required by statute, it is not on the form that we have on the AOC website. However, as Judge Hagan and others have said, there is no prohibition to a county adding information. It's just something that, as far as a uniform form promulgated by the court system, that to be added without having that legislative authority is what's difficult there. So if this council wants to add that, that is within the purview of the council, but that's why the information is not on the current forms as they are provided. But the counties, can add information as they see fit, which they have.
Anything else?
I would just add that from a law enforcement perspective, that I agree with Judge Hagan that if this were to be presented in legislation, that the enforcement process would need to be very clear on how that would be enforced should those situations occur, because when law enforcement is out in the field having to enforce legal documents, especially court-ordered situations, that can be confusing. So that would need to be also an aspect that would have to be thought of. That's all I have.
Ms. Bullard, your hand's still up, but I'm assuming that do you have anything else you would like to add?
I re-raised it.
Okay.
Put it down and put it back up.
All right, go ahead.
The other context to Mr. May's question about the history around that is that the opposing perspective is that it is required to be in the form because the statute says that this person must dispossess by lawful means, and because it's impossible to prove lawful means without at least a basic acknowledgement of who the third party is in that form. So that's been the counter argument. I know Ms. Consiglio Young had talked about the kind of back and forth that's happened on the council, and that's where that's come from, because the legislation and, as we all know, many of our statutes do not lay out line by line what should be in the form. And this statute does say that it has to be by lawful means. And in order to prove those lawful means, the form is required to have at least the third party's name and information.
Thank you. All right, not seeing anyone else wishing to speak. And if there is no motion, we will move to table this issue for a vote at the next meeting. All right, I think that concludes the business of the Domestic Violence State Coordinating Council. I do want to remind everyone of the dates for 2026. The proposed meeting dates are Friday, March the 6th, Friday, June the 5th, Friday, September the 11th, and Friday, December the 4th. Are there any questions or comments from council members regarding anything from this morning's meeting? All All right, seeing none, thank you for your time this morning and for being patient with me as I moderated the meeting. And thank you all for the important work that everyone does for Tennesseans. And this meeting is officially adjourned at 10:35 this morning. Thank you.